Hi everybody, my name is Michele Di Bari and I am the professor in charge of teaching the course International Organization and Human Rights. This course is entirely taught in English because you will work with human rights at the international level, so it will be meaningless to teach this course in Italian. Today I will give you a lecture on one of the topics we will analyze during the course, which is the principle of equality. Now, usually when we work with human rights, we refer often to the principle of equality, which is different from the principle of non-discrimination, but we will see how it works. Now, as you can see in the first slide, usually when we think about equality, we think about a relation between two or more individuals. So I would like to, usually I ask my classroom, but if we say that A is equal to A, is this a relation of equality? In a lot of occasions, the class divides itself in two different groups. There is one group which says, yes, A equal to A is a relation of equality, and there is another part of the class which doubts a little bit about this possibility, but it doesn't have a proper answer. So we may say that A equal to A is not a relation of equality. Why? Because A equal to A is a relation of identity. So it's quite normal, it's perfectly normal for a legal order to treat all A's as equal. As you can see in the third slide, A equal to B is a relation of equality. Why? Because in legal terms, in order to have a relation of equality, you need to have what I call a next rule, so a legal rule which identifies a common qualities all individuals or elements must have in order to be treated equally. So, getting to the slide number 3, a relation of equality means that A, B, C are not identical. However, they can be considered equal according to the X rule. Thus, establishing a relation of equality is a matter of finding an X rule, so a legal rule, which, according to the legal order considered in that specific historical moment, creates a relation of equality. The element of time is important. Why? Because if you consider a legal system in a specific period of time, you can have a different understanding of equality. What was equal 20 years ago, for example, can be considered unequal now. So the understanding also of the X rule may change. Now, the X rule, in order to establish a relation of equality, must identify a quality shared by all individuals. So we can have different X rules. In the slide I put X1, X2, X3, and they may establish different criteria for considering individuals equally entitled to some or all rights. Now, what is a legal rule? Because when we look at this X rule, we should also wonder, what is a legal rule? A legal rule is a legal provision which is written, so it's a literal transposition of a rule or a value, which is not, of course, a concrete thing, though it leads to concrete consequences. So it falls within the realm of intellectual activity, thus judges must preliminarily construe the meanings around the words composing the literal provision. So when you have a legal rule, you have also a social actor whose aim is to interpret the legal rule. This social actor is the judge, usually. So it is quite important how the legal rules is written and how the meanings of those words are given by the judge. So the question is also about the process of interpretation of that specific legal rule. Now, we will not get really in deep about the process of interpretation. If you will follow this course once you're enrolled at Ciels, we will develop this argument much more deeply. Now, let's get to another principle which is usually considered together with the principle of equality, which is the principle of non-discrimination. Sometimes, and it is a mistake, students believe that equality and non-discrimination are overlapping concepts. So you can consider equality, or you can use equality as a synonymous of non-discrimination. This is not true. This is a mistake, because equality drives to the creation of the X rule, able to recognize equals, but the principle of non-discrimination intervenes a posteriori, which is a Latin definition. The principle of non-discrimination becomes essential once a rule has been passed. So a rule has been created, and it is needed to evaluate whether the principle of equality has been respected. So through the lens of the principle of non-discrimination, we may verify whether a law created having in mind the principle of equality is in fact, so in reality, producing equal treatments or a discriminating treatment. So it is widely accepted that equality and non-discrimination are positive and negative statements of the same principle, but equality means the absence of non-discrimination, while upholding the principle of non-discrimination between groups will produce equality. Now, there are some principles related to the idea of equality of non-discrimination. The main principle is reasonableness. So, when we talk about rights, it would be unreasonable to underestimate differences among individuals as well as among different situations. So, for this reason then, differentiation does not automatically lead to discrimination or inequality. On the contrary, there could be a compelling public interest differentiating among different subjective positions. In other words, using reasonableness, you can achieve equality also by considering differences. Indeed, while equality is usually understood as being equal before the law, this is not sufficient. Why? Because sometimes if the law treats equally everyone in society, this can create discrimination and unjustified discrimination. Think about a possible law which would treat equally everybody in terms of paying taxes or paying educational fees or university fee. So if you have a law which establishes that the university fee per year is 10,000 euro for everyone, this is not equal because not everyone can afford to pay 10,000 euro. So in this case, equality means treating differently different individuals coming from different social positions. So for example, it would be absolutely reasonable to have scholarship for those who are in need and provide fulfill payment for those who are not in an economic need. Now, when we look at the principle of equality at the international level, we find the principle of equality written in a number of international human rights treaties. Now, before 1945, the prohibition of discrimination was only dealt with in the so-called minority treaties, which were very limited in their scope. So the idea was, let's treat on an equal basis those minorities which are composed by individuals who belong to my ethnic group. So states wanted to protect their social minorities abroad. Now, with the adoption of the UN Charter, a non-discrimination clause applying to everyone became a recognized part of international law. So the idea that the United Nations should become the international protector of the rights of the individual grew out on, of course, the tragic experience of the Second World War. And the idea was, we have to push forward the principle of equality when it comes to the implementation of human rights, otherwise we will get back to conflicts. And indeed, the UN Charter states that its aim is to develop friendly relations among nations based on the respect of principle of equal rights and self-determination of people, and promote and encourage respect for human rights and fundamental freedoms for all without discrimination as to race, sex, or language, or religion, or any other grounds of discrimination. The Universal Declaration of Human Rights, which is the first UN attempt to proclaim the importance of human rights, elaborates on UN Charter's equal rights prescription, and the principle of equality pervades the whole declaration. On 30 articles, some are in one way or another explicitly concerned with equality, and the rest are implicitly referring to it by emphasizing the all-inclusive scope of the Universal Declaration of Human Rights. Example, Article 1, all human beings are born free and equal in dignity and rights. Article 2, everyone is entitled to all rights and freedoms. So everyone, always, the reference is everyone. And what are the first steps toward the achievement of equality? The Subcommission on the Prevention of Discrimination and Protection of Human Rights was created, established in 1947 by the United Nations, and it was meant to deal specifically with the question of discriminations. So, how to remove inequality. And early in the first session, the Subcommission did not attempt to agree upon a legal definition, but merely indicated some consideration which should be taken into account when framing the Universal Declaration. Prevention of discrimination was described as the main aim that should be driving the drafter of the Universal Declaration. And the Subcommission held that differential treatment of groups of individuals was justified only if it was exercised in the interest of the community as a whole. So, differentiation can be possible only if there is a public interest to pursue. Now, we have a number of international treaties covering the principle of equality. Among them, we can list, for example, the Convention on the Elimination of All Forms of Racial Discrimination back to 1965, and also the Convention on the Elimination of All Forms of Discrimination against Women back to 1979. But now we are used to think about international treaties on human rights having as a driving principle human rights, as a driving principle the principle of equality and non-discrimination. It's an underlining principle. And if we look, for example, at the two conventions I just named, so the Convention against Racial Discrimination and against discrimination on women, and we look at the two articles 1, we can read that Article 1 of the Convention on Racial Discrimination defines racial discrimination as any distinction, exclusion, restriction or preference based on race, color, descent, and so on. And if we look at the same principle in the Convention on against discrimination against women, we find that discrimination against women is defined as any distinction, exclusion, restriction made on the basis of sex. So the formula is the same: any distinction, exclusion, or restriction based on. This is discrimination. Now, when we talk about discrimination, we usually can differentiate among two big groups: direct discrimination actions and indirect discrimination. Direct discrimination is quite easy to be found, and if you will become a human rights defender, you will find quite easy to identify whenever direct discrimination occurs. On the contrary, it will be quite uneasy to identify when indirect discrimination is performed. So direct discrimination is when person A discriminates against person B directly on a specific base. So when A treats B favorably, then when A is treated better than B according to an assumption which is discriminatory in nature. Example, I may say that only white people can use public transportation, or only white people can sit in front when getting on a bus. In this case, you are directly creating a differentiation, which is disfavoring discrimination against a specific social group, black people. Indirect discrimination and direct discrimination, is easy to be identified because it usually is written on the rule itself. So there is a rule, a written rule, in which you can find a differentiation between two ethnic groups or two different racial groups. Indirect discrimination is uneasy to be identified because usually when you look for indirect discrimination, you have to investigate on the consequences of a specific legal measure. Indeed, a legal measure usually is written in very natural terms, so you cannot really understand what will be the outcome of that specific legal rules application. Example, if you say that in order to become a teacher, you must undergo a public selection, and among the documents you have to present, there is also documents related to having served the military, the military, so the armed forces. And you are in a system where only male can serve the army. This will immediately create a discrimination because women will never apply for the selection process because they would never be able to produce the documents of having served the army. In this case, the legal rule doesn't speak about discrimination because the rules itself is neutral. It doesn't say only male can participate in the public selection, but one of the requirements, so one of the documents you need to have is a document that can be produced only by male. So indirectly you create a discrimination even if prima facie the legal rules doesn't create any differentiation. In this case, you don't have to focus on the legal rules itself, but on its consequences. And then you find that there is a discrimination, though is indirect. So it is not written clearly in the rule. Now, in order to overcome discrimination and in order to overcome inequalities in societies, during the years, states have used some specific legal measure in order to rebalance historical disadvantages in society. And these legal measures have been called affirmative action, where they were burned, so in the United States, or positive action here in Europe. Affirmative action were created in the United States in order to promote and to, rebalance the situation of African Americans in particular, while positive action in Europe were mainly created and aimed at rebalancing the situation of women, so gender empowerment. Affirmative actions are legal measures or policies which create differentiation among social groups, creating a temporary advantage to the disfavored social group. So they create differentiation in the social community, and they give some advantages to a specific social group, to specific people. These advantages, of course, create a sort of inequality framework, but this inequality framework is justified by the exigencies of rebalancing and historical differentiation and historical disadvantaged position. Now, affirmative action or positive actions, in order to be legitimate, must be temporary, exceptional, and proportional, which means you can favor a specific social group, but you can do that only for a limited amount of time. How long? For the amount of time necessary to rebalance the situation between different social groups. Exceptional, which means that usually the normal rule is applying the principle of equality and non-discrimination. You can apply an affirmative action, so you can apply a discriminating approach to a specific social group only if you have a public interest to pursue, in this case, restoring imbalances in societies. And the rule, the measure, must be proportional, which means, for example, if you want to achieve gender empowerment in terms of women participation in public life, you can establish, as an example, a system of quotas. So you can make a specific quota reserved for women in terms of seats in the parliament. A proportional measure can consist in reserving the 30%, the 30%, maybe even the 50% of seats in parliament. But it would be disproportionate if the system of quota would reserve the 60% of seats, because in this case you are not pursuing equality, you are just reversing discrimination. So you are making the weaker social group the stronger social group. And this is not the case when it comes to affirmative action. Now, I will get just to the last point, and then I will stop for today and we will stop this open lesson. Now, the debate on positive action has been quite huge in the last years because the legal doctrine is divided among those who are, proponents of more positive actions and those who are in opposition of positive actions. Proponents explain their idea of a positive action, in particular when it comes to minority rights or women's rights, as, the idea of creating an effective remedy for historical discrimination. So the idea is society is not able on its own to create the basis for equal treatment for all, so it is necessary for the state to intervene positively, so through effective measures. Opponents, on the other hand, argue that it is impossible for the state to identify exactly what will be the right measure to be applied, and the idea of preferring a social group over another one creates or poses a risk for the principle of equality itself. So the idea is, whenever the state favors a social group, you create discrimination against the others not favored group, and so this is a risk too dangerous to be to occur. It's better for the state not to intervene. So it's better for the state to leave the free market to adjust the situation. On the other hand, we may say that if we look at what happened during the years, this free market approach doesn't seem to work quite well. So it is necessary to intervene with some adjustments on the side of the state. So that's all for today, and I hope I will see you in class if you enroll at Ciels.